Welcome, everyone. Glad to have you aboard for another episode of the Silicon Valley Arbitration and Mediation Center webinar series brought to you by the Programming Committee. Today's session is titled Not Business as Usual, Techniques for Resolving Life Science Disputes. It's my pleasure today to introduce our session moderator, Angela Foster. Angie has one of those bios that when you read it, you think to yourself, wow, I'm pretty lazy. So we'll see if you agree. She's a member of the SVAMC tech list and a member of the executive board. She's also a registered patent attorney, arbitrator, and mediator, specializing in litigating, negotiating, and resolving life science disputes. Angie is a fellow of the College of Commercial Arbitrators and a member of several ADR panels, including the American Arbitration Association, the International Institute for Conflict Prevention and Resolution, and the World Intellectual Property Organization. In addition to her law degree, Angie holds a doctorate in biochemistry and molecular biology. So basically you're classic underachiever, right, Angie? Okay, I'll hand it over to you, Angie. The screen is yours.
All righty, thank you. I'd like to thank again the Silicon Valley as the sponsor for this program. I just want to say a little bit about Silicon Valley before I get started. It looks like my computer is shining that there's a little instability, so give me a moment here. Make sure my connections are all correct. All right, Silicon Valley is a nonprofit foundation that promotes efficient technology dispute resolutions, including advancing the use of arbitration and mediation in resolving technology-related business disputes. Silicon Valley doesn't administer cases, but it promotes educational programs related to resolving technologies, as I said before, that involves businesses. It provides resources, educational programs, as this one that we're about to present. It also publishes a list of what the world's leading technology neutrals called the tech list, and all of the panelists today are members of that tech list. And so I'm going to introduce the panelists in alphabetical order. The first one being Stephen Gilbert. Steve is a fellow of the College of Commercial Arbitrators, a fellow of the Charter Institute of Arbitrators, a fellow of the American College of Neutrals, a member of the National Academy of Distinguished Neutrals, an American Arbitration Commercial Master Mediator, a CDR accredited mediator, and he's on the Silicon Valley tech list, as I mentioned before. Prior to entering as a full-time neutral, he was a computer programmer, chemical engineer, and a patent, trademark, and copyright attorney. He has arbitrated and mediated dozens of commercial, licensing, technology, and intellectual property disputes. Our next panelist is Harry Samaras. Harry is an independent arbitrator and mediator, focusing her practice on complex commercial cases involving intellectual property, and business and technology issues. She's a distinguished fellow of the International Academy of Mediators, a fellow of both the College of the Commercial Arbitrators and the Chartered Institute of Arbitrators. She has worked as an attorney in the corporate and private sectors, as a staff attorney and law clerk of the Federal Circuit of Appeals, as well as a patent examiner for the United States Patent and Trademark Office. Our final panelist is Connor Weiner, who has an extensive experience in mediation and arbitration of complex commercial technology, life sciences, healthcare matters, with numerous providers, including the American Arbitration Association, ICDR, the Center for the Conflict Prevention Resolution, which is better known as CPR, and the American Arbitration of Health Lawyers, as well as JAMS. She's a fellow with the Chartered Institute of Arbitrators and holds a number of leadership positions with bar and professional organizations. Connor brings to her mediation arbitration practice a unique combination of domestic and international litigation, transactional, and in-house experience from places such as Novartis. Today, what we're going to try to do is we're going to talk about appropriate dispute resolution techniques that can be used in life sciences. And I want to emphasize the word appropriate. One of the things we want to try to do today, and hope that it continues, and we know that colleagues in the field are doing the same thing, is to get away from the word alternative. Instead, we want to just rather than putting a box and checking a box, we're going to look at what is appropriate technique that should be used when you have a different dispute that involves life sciences. And we're going to try to present that by showing you different techniques that can be used, and then later giving you case studies of these different techniques and how they can work and have worked from experiences from the panelists. So at this point, I'm going to have Harry come in and talk a little bit about life sciences industry from the perspective of what we're going to talk about today.
There are a lot of ways to define the life science industry. We've chosen to define it as the individuals, nonprofit entities like universities, and for-profit companies that are involved in the research, development, manufacture, commercialization, and distribution to end users of products for the diagnosis and treatment of human, animal, and plant diseases. And as suggested by the next slide, examples of products include things like, can you go to the next, there we go, thanks. Include things like pharmaceuticals, medical devices, diagnostics, vaccines, and agricultural chemicals. Kana?
Well, sometimes I go to cocktail parties and people learn that I'm a mediator and they say, oh, you do divorce mediation? Well, sometimes when I talk about what kinds of disputes arise in the life sciences industry, people say, oh, you do IP? We really want to emphasize here that disputes in life sciences, companies, industry generally, can happen at every stage of the life cycle of a product, research, development, manufacturing, commercialization, and it includes intellectual property, certainly, but also disputes among partners and entities trying to bring products to market in a highly risky area with lots of money at stake, and disputes that are often global in nature, collaborations, investments, development, commercialization, supply chain issues in connection with manufacturing, and that's not to mention mergers and acquisitions and earnouts at every stage of the process of bringing a product to market. So it's not just IP and it's not just product liability, which is sort of at the end of the spectrum, but at every stage there lurks the potential for disputes. Angie.
All right. So to further what Harry as well as Connor just spoken about is that one of the things that we talk about when we talk about resolution, and specifically today, is what techniques are needed to resolve that particular dispute. How do you resolve this particular problem? And all of these different tools can be for different reasons and should be done and utilized at different stages. So right now we're going to run through some of the different types of tools that you can use. And then later we'll talk about case studies that utilize these different tools. The tools are going to run the gamut from self-help, which is probably the most broadly and least restricted technique you could use, all the way to litigation, which is probably the most expensive and most restrictive. So starting first with self-help, we're going to talk with Steve.
Okay, let's step back for a minute. What are the reasons for trying to obviate disputes? I think it should be obvious to everybody on the line. Disputes interrupt your conducting business. They divert resources, money, people, and time, and for most people are unpleasant to deal with. Therefore, doesn't it make sense to try to avoid having disputes unless a problem is serious enough? So if that's true, that you want to avoid having disputes unless a problem is serious enough, how do you infuse a commercial relationship with that recognition? So the first thing we would suggest doing is try to build dispute management techniques into the contractual relationship. This particularly makes sense in the life sciences, where there are more and more interrelationships between parties. And when you ask, I've been on a number of webinars over the last few months where people are talking about life sciences and other types of commercial enterprises. And without fail, the number one reason for engaging in some sort of self-help or alternative appropriate dispute resolution is to try to maintain relationships. And people seem to agree that that's an important characteristic of life sciences. So what do? It could be as simple as having a relationship manager in your company to talk to the relationship manager in your counterparty's company. You want to pick somebody who has good people skills, who can pick up the phone and talk to somebody and find out what's going on. You probably want to have them schedule regular calls at least once a week just to kick the tires, so to speak, and see how things are going. These people in pharma are often referred to as alliance managers. What else could you do? If it's going to be a really long-term relationship, or maybe something with R&D where parties have to do different things, you could have joint steering committees, and those should meet. Those would have more people on them with representation from R&D, the business people, marketing, and those could meet once every calendar quarter, every half year to set policy and survey the landscape. That does not detract from the need to probably have an alliance manager who's going to be watching everything going on. Another thing you could do is have dispute resolution boards. These are common in construction. It's not unusual in the construction field to have people, neutrals, who join a project and know the project from the outset and are there to help iron out any wrinkles, so those wrinkles don't become irritations that later turn into disputes. There is a dispute resolution board foundation for the construction industry with over 1,000 members and representatives in over 70 countries. And its website is drb.org. And I suggest if you're interested in dispute resolution boards, you might want to go there. If there is something that the alliance managers have not been able to deal with, what do? Well, the first thing is, under self-help, would be negotiating by the parties. You get an officer, you get the manager who's not involved in causing the problem. You get people a little higher up in the organizations to talk to one another. Now, I know Kana has very specific experience in pharma with respect to dispute resolution boards, so I'm going to pass the talking stick to her.
Well, I'll talk about that, I think, in the context of the scenarios. But I do want to emphasize here, as we go on from self-help to other possibilities on the menu of dispute resolution options, that when I was a general counsel, I tried to keep my clients in self-help as long as possible, using some of the techniques that Steve has identified, and we'll talk about that a little bit more in the context of our first scenario. But once you get out of self-help, you lose control. And in the context of life sciences, you raise the issue of confidentiality. The best way to keep a secret is not to tell anybody. And with all of the paper in the world, confidentiality agreements, et cetera, the more cooks are in stirring the broth, the less confidentiality is protected. So using just the parties involved to try to resolve the dispute was something I really strove to accomplish. But if you can't do that, the next step is to look to various ways that third parties can be brought in to help. And one of those is to have a real-time standing neutral or a dispute resolution board. Real-time involvement of third parties, again, as Steve said, it grew out of construction, but it is definitely something to consider in connection with life sciences disputes. A standing neutral can be a standing mediator. A dispute resolution board is a little bit more formal, but we will talk about those options in the context of our scenarios. And I don't think that enough attention has been paid in connection with life sciences disputes to some of these real-time options. Everyone's familiar with third-party mediation after a dispute has arisen, but getting people involved as it's happening, so they know the project and they understand it. As we'll see, we think that that is a fruitful area of inquiry. Harry.
So after a dispute has arisen, two voluntary post-dispute processes we want to just mention here are mediation, standby neutrals. We're going to talk more about mediation in the scenarios. I just want to mention here, pointing out the flexibility of mediation. So always keep that in mind, because once a dispute has arisen, mediation can be used, for example, during the course of in parallel with an arbitration or litigation. It can be used after an award has issued, or after a jury has come back, or after judgment has been entered. It can be used on appeal. So mediation is very flexible, can be used most anytime post-dispute. Standby neutrals are also, I've seen them work very effectively. I was once privy to a situation where there were two large corporations that had ongoing but intermittent disputes. They settled on a neutral. They settled on a process because it was always the same kind of dispute that came up. There was a certain regularity to it, and it was a very efficient way of getting an answer. So standby neutrals can be a very effective way when you have ongoing disputes between companies, for example, or a dispute has already kind of made it to hit the either arbitration or litigation. Kana.
Thank you. Next slide, please. Sometimes in connection with an attempt to resolve a dispute, and this has happened to all of us on the panel, you hit a technical roadblock. The parties can't get past the idea that it was somebody's fault that the design project did not work, or the diagnostic assay could not be developed after 10 years. That's a real story. And instead, they can't get past that, and they're not willing to back down in the context of a mediation or a negotiation. So sometimes in life sciences cases, it's very useful to think, well, instead of running off to arbitration or litigation, perhaps we should try to break this impasse by using an expert in connection with a mediation or an adjudication. Expert adjudication is familiar to those of us who have done mergers and acquisitions and deal paper like that, because often in connection with accounting disputes, what is the working capital? Do we need a purchase price adjustment? An accountant will be written into the contract, and that accounting professional has the right to issue a binding determination. So similarly, I've explored with clients using an expert adjudicator before running off and doing a longer arbitration litigation process. Another thing on our menu here is early neutral evaluation. My colleague at JAMS, Wayne Brazil, has written the classic on this mode, and in my view, and it involves making a presentation to an expert in the field who then issues an early neutral evaluation. There are no ex parte communications with this neutral before the presentation. I'll describe that a little bit more in connection with one of the scenarios. But the key fact on here for this part of our menu is if there's a technical impasse and the parties can't agree to disagree about it, there are other things to do before you run off to arbitration or litigation. And now we go to Angie to talk about mini trials.
Okay. I'm going to talk a little bit about some of the adjudication. We mentioned, as most people know about arbitration, but there are also other techniques that you can utilize that either for arbitration or for litigation. And mini trials is one of them, where parties will often get people to serve as what would be a mock jury. They will present the case before this group, and then it's usually one side that's doing it. And then they will probably present questions to that group to later evaluate what has happened. And that gives a party a sense of, if we were to go to trial or arbitration, what might happen. Now, mock jury trials tend to be just that. you tend to try to have a situation where you can have a trial that it actually happens before what you would think is a jury. And it's a little bit different than the mini trials, but not much. The mock, and we're going to talk about this a little bit more later, mock arbitration is something that I think most people are not as familiar with. The mock arbitration seems a lot like, say, mock jury trials, but it's not. In the mock arbitration, which Steve will talk about later, is scenarios where you hire a person or two who are serving as arbitrators, who will either, you will present the case to them before you proceed with arbitration or during arbitration or whatever, and get a sense of what your arbitration case might be like. And arbitration, as we know, is an agreement between people that in the event that there's a dispute that you'll go to arbitration. Its counterpart, of course, is litigation, where there's absent an agreement and the parties have not decided to do that, and that they will go to arbitration. We also mentioned mediation, but mediation is not in this list because it's not an adjudication. However, when you talk about a hybrid here that's listed, a hybrid is assuming that that you're either going to an arbitration, adjudication of some sort, arbitration or litigation, and you decide to do a mediation either before the arbitration or litigation occurs or either in the middle of it. And again, we will give case studies of that as well. Now, I think I didn't mention it earlier, and I wanted to make sure I said this now, that we have reserved time at the end for questions. However, if you have a question, you can put it in a Q&A box on your screen, and we will be monitoring it if we think that it's a question that needs to be addressed right away. So otherwise, we will do Q&A at the end. All right. Now, what we're going to do now at this point is switch to some of the case studies to give you a better sense of how some of these tools that we've described are used or have been used, and what type of lessons or tips that we got from those particular situations. Now, the first one is going to be with Steve and Connor. It's called real-time resolution. And they talked a little bit before about dispute boards, and then I'm going to talk about a little bit how it's used in or can be used with life sciences, and if there's any potential obstacles that parties might encounter or should think about when dealing with real-time resolution. What we've also done, as you're going to notice here, is that we've created these little teasers for each one of the scenarios, and some of them will have a meaning that becomes apparent and some of them won't. Steve, you have here, nip it in the bud. Is there anything you want to say?
Anybody who's on this call should understand within 2 minutes, if not immediately, what the point of that is, what the meaning is. But
Okay.
if you don't, you're more than welcome to put it in a question. Okay, so in our first scenario, we have a non-US company that licensed companies in different parts of the world, and it was interested in licensing US company. It had been burnt badly once before in dealing with a US company, protracted litigation, expenses. This foreign company was not happy. But the US market is too darn good to continue to ignore. So what did the parties do? The parties being the foreign company and the new US company. After a lot of discussion, they entered into a set of renewable multi-year agreements, trademark, copyright, know-how, raw material supply, and each agreed to have a dedicated point person within each organization monitor the relationship. This is the alliance manager that we mentioned before. That's what's doing there. The parties also agreed to a step dispute resolution procedure, including having a dispute resolution board comprising a panel of pre-screened neutrals to mediate, and if that didn't work, then to arbitrate. And the mediation and the arbitration would come about only if the relationship managers and then officers of the companies couldn't work things out. The agreement put a tight schedule on the arbitrations, 120 days after service of demands, simple award, splitting the costs of the arbitrator. I'd like Kana to chime in now concerning dispute resolution boards, particularly for pharma.
I was being a good girl and I muted myself. Just a word about pharmaceutical strategic alliance management, and then a little bit about various forms of dispute resolution boards. I have had terrific experience as a negotiator and implementer of global arrangements with alliance management. There is Steve mentioned the Dispute Resolution Board Foundation. There is an association of strategic alliance professionals, appropriately named ASAP for short. And if anyone's interested in materials or understanding what that point of view is all about, I would recommend that you look at some of their programs and maybe join. It's a very reasonable cost. The problem there, though, is the alliance managers are not neutral. They are employees of the company that they are representing, and that inevitably limits how far they can go in trying to resolve a dispute. And there are often issues with respect to how much authority they actually have before they have to check with the numerous stakeholders inside pharmaceutical companies. But it's one way that pharma companies deal very well with managing disputes and dispute prevention. I've talked to life sciences companies about dispute resolution boards. We could do a whole program on dispute resolution boards. There are so many flavors. Will the dispute resolution board issue just an advisory opinion or a binding opinion before you go on to arbitration, et cetera, et cetera? I think that some of the thoughts and concerns that I have heard are, one, well, we already have all these pharmaceutical strategic alliance managers, and we have, as Steve was pointing out, these committees that are supposed to deal with disputes. So we've got built-in self-help mechanisms to prevent disputes. And if those mechanisms don't work, then we've got to do something else. So because pharma has such significant money on the table and incentive to avoid disputes, they do have these mechanisms, and that's a good point. The other issue is, I would say that even in the construction industry, I've heard that this mechanism has it's raised concerns about cost. Hiring 3 experts, keeping them involved, having them come to meetings, letting them know how the project is going for a long time in construction, that's quite a bit of money. And these collaborations with pharma companies can go on for 10 years. So there is a concern about expense. A single standing neutral might be better. And last but not least, there are these confidentiality issues. Bringing 3 professionals into a long-term relationship like that, I've heard some concerns about that from life sciences professionals. But I still think it's worth talking about, and there are so many flavors. We don't have time to go over them here. I still think it's worth trying to avoid disputes by considering that option for real-time resolution. Steve, why don't you let us know what lessons we are learning from your nip in the bud scenario?
When parties are committed to their relationship, a way can usually be found to keep the peace, except in the most egregious circumstances. It's obvious for anybody who's in any type of relationship, personal or business. If you want to make it work, you can usually find a way to make it work. Okay. And if you get the right people, if despite your best efforts that sort of self-help doesn't work, then and the officers of the companies haven't been able to resolve things after the alliance managers took a crack at trying to fix it, dispute resolution board people, standing neutrals. If you have good people ready, I think you probably have 98, 99% of your disputes resolved by this point.
I agree with that. I agree with that.
Okay. Next, we're going to talk about internal earliest case assessment. When a party finds himself at the point of a dispute that's about to arise, the first thing they want to say to themselves is, what should I do first? And Harry's going to talk about that. Her teaser is line up your ducks. Harry.
Okay, so this is the story of two companies, a small company and a large company. The large company was a multinational company. The smaller company had the initial design for a medical device and the expertise in the field and the nimbleness. And they were looking at the larger company for manufacturing prowess, distribution prowess, and money, of course. And they started collaborating on this medical device. And what happened was they became frustrated. The two companies, one being small, one being large, they basically had two kind of personalities that in the end, the working relationship just didn't work. The larger company got frustrated and went off on its own to kind of carry through the work that they were working on with the smaller company. And the smaller company became upset because they felt that the larger company had misappropriated, very valuable trade secrets. And they filed suit, small company filed suit in state court requesting a $750,000 in damages. And this was a long time ago. Just so happens this case was, it'd probably be a lot more now. And the claim was trade secret misappropriation. So what happened? So the in-house counsel contacted the vice president of the business unit in the large company that had been working with the smaller company and said to him, what's going on? And the guy said, look, my right-hand guy would not have permitted any misappropriation. We didn't take anything, but even if we did, it wasn't worth much. And then he started spouting the law on inevitable disclosure doctrine. And although we're not going to go into the details of that, I'll just say that it wasn't applicable. So the in-house counsel suggested that they engage a outside counsel who was a litigation counsel who would help to show the large company that this is kind of a serious, problem that they have. And what they did was they first identified the group of folks in the large company that had been working with the smaller company. They went and they actually propounded document requests, a short, maybe 6 document requests to these folks, collected the documents, reviewed the documents, and then sat down with the folks and interviewed them and put together a timeline. And from that interview timeline and the documents, the outside counsel created a PowerPoint presentation that could have been, the other side, the smaller company's opening statement in the misappropriation case. The in-house counsel and outside counsel invited the business VP, to sit down and to hear the presentation. And what came out of things was that the timeline kind of showed when the parties started working together, when the confidential information was, it passed to the larger company, when the breakdown occurred, and how quickly the larger company kind of got up to speed in doing and carrying out the business that the companies were supposed to be doing together. There were also emails from the business VP's right-hand guy, who he relied on, and and these were not protected emails, no attorney-client privilege, et cetera. And the email said, look, this is the technology of the small company is revolutionary. And it showed how valuable it was, kind of estimated it being at least 1.5 million. Remember, the smaller company was suing the larger company for 750 million. and 750,000, pardon me. Some of the other things showed that the frustrations, emails kind of showed that there were frustrations with the company, between the companies, and that there had been attempt to clean room the situation so that the larger company could go on and do it, do the work that they had started, but with a clean room, meaning that, here was what we wanted to do generally, but we have a new group of people on and new ideas, et cetera. We didn't use anything from the smaller company, and that was botched. At the end of the presentation, the VP got up from the table, made a phone call, and came back and gave the instructions to the in-house counsel to settle the case for what they were asking for in the litigation. So the lessons learned are very simple. Going back to getting your ducks lined up. First of all, don't assume facts that underlie a dispute. People have the best intention oftentimes, but we're human beings, and no matter how high up or prominent or engaged the person that you're speaking with in the company could be, oftentimes people forget dates, they forget the order of when things occurred. They, forget facts, very important facts and things that they said in their emails, for example. And perform, if you're doing early case assessment, perform the due diligence on the facts and the law. I mean, the critical part of this presentation also, in addition to those facts that I told you, was to straighten the guy out, the VP out, in terms of the law that he was given by somebody who wasn't up to speed on the applicable law. And to decide and to do all these things, to get the facts nailed down, the law, and early, so that you can decide whether to resolve the case and how to do it. So for example, here the case was resolved confidentially in kind of a very, not really even a big negotiation, just by picking up the phone and saying, here's what we're going to settle for this. If that hadn't worked, obviously, with what they found out during the investigation, they probably would have wanted to use mediation, because the information that would have come to light from the large company would have made it look very bad. So that is the story of getting your ducks lined up, and those are the lessons learned.
Okay. Next, we're going to go to mediation before litigation or arbitration with Connor. And as we had mentioned earlier, sometimes doing litigation or arbitration isn't the best mode or avenue, and it's clearly not the only avenue. And so what do you do if you want to do mediation, it's not in your agreement, and when should you possibly suggest it? So Connor's teaser is keep cool.
Keep control and keep cool.
I'm sorry.
Either one. All right. Next slide. I like yours better, Angie. Thank you. And here is my scenario. I'm going to give you more details than are on this slide. So Oncology Health, a multiple hospital health system, wanted to significantly upgrade its profile in the treatment of cancer. Oncology Health's CEO and the CEO of Zapit Integrated Systems, a major radiation oncology hardware and software provider, entered into a 15-year collaboration pursuant to which Zapit would replace Oncology Health's current radiology equipment and associated software. So Zapit was to provide on-site assessments of Oncology Health's needs, 10 highly sophisticated, cutting-edge pieces of radiation equipment that cost $1 million each. The phrase cutting edge was in the 10-page contract documenting this 15-year collaboration. The software necessary to operate the new equipment, along with lengthy maintenance obligations, project management, and data transition, and help with customization and implementation of the new system. All of the entities involved, including many subcontractors helping Zapit, worked together on the project for over a year. Now, at that point, Oncology Health began complaining to Zapit about the pace of the software assessment and implementation, the fact that several test runs had not worked, and that the incomplete transfer of some patient data to this new radiology system just made it impossible to use the new equipment. In addition, Oncology Health claimed that the promised equipment upgrades were not delivered on time and also were not working. The leader of the team of doctors that was assessing this project for oncology health was a self-confessed fan of the system that was currently being used, which we will call wronged radiation, and was especially critical of ZAPIT. The doctor leader was also a paid speaker for wronged radiation. Now, Oncology Health began a letter writing campaign to all of the companies involved. And after over a year of arguing, and here we're back to the second bullet point here, Oncology Health terminated the collaboration, claiming, among other things, that ZAPIT had mismanaged the project and that ZAPIT's equipment could not meet the specs. The contract has an arbitration clause, but no requirement, not yet on the lessons learned.
Okay.
They're giving it away.
I'm sorry.
Yeah,
I'm sorry.
Go back. I don't want people to get the impression that I'm against arbitration. 50% of my practice is in arbitration. I believe that a well-managed process can be wonderful. But if you were the general counsel of ZAPIT and you looked at this scenario, a litigation would appear to be a very nasty, technically complex affair with many witnesses, potentially years of discovery, numerous documents, depositions, expert disputes, extensive expert testimony. It looks like a mess to me. And arbitration, although much better, would be similarly complex. It would be shorter, it would be more efficient, there would be less discovery, but still picking through this landscape would be pretty ugly indeed if I were the general counsel looking at this scenario. So one thing that people lose sight of is that any arbitration or litigation exacerbates conflict, it hardens positions, and it takes the case out of the business negotiation realm. I mean, the business loses control of the dispute. In addition, this has happened in at least 2 or 3 of my cases. The fact of the filing of an arbitration or a litigation inspired the filing of a retaliatory counterclaim. In 3 cases, I have had general counsels tell me I never would have brought that counterclaim if I hadn't been sued first. And in addition, there's an immediate expense in any litigation and also arbitration these days. If you're being conscientious, you've got to do the case of investigation that Harry was talking about. You need to get an outside counsel team up and running. You need to, in a litigation, hire a discovery vendor. You will have a document hold put on your documents, etc. So not that you can't avoid that if you're going to do a mediation. So there are many, many ways, reasons not to take that next step. And it's also, if you're going to be successful in a pre-arbitration or litigation context, I have a few recommendations here, and we followed this in this scenario, which is partly made up, but not in its significant aspects, a real story. I really encourage everybody to put together a litigation mindset. We're not in litigation yet. We're not out to win the mediation. And also, it's very important not to hold back strategic facts because you think you need that ammunition for later. You need to use the pre-mediation preparation period, and really it becomes a process consisting of looking at your facts, really using the mediation process before you get together to do that early case assessment that Harry was talking about. You have to exchange statements. There were, in this case, I'm referring to, there were 20 letters back and forth, and everybody said, oh, we already know it already. We know what they think. But taking a fresh piece of paper and exchanging statements so that the mediator doesn't have to do all that heavy lifting in the mediation is very important, especially at this early stage. You really want to keep business people involved. I've had mediations where the litigators decided to keep the tone right because there was no litigation yet, that they weren't going to attend any of the mediation sessions. They made that very deliberate choice. They were in the background counseling their clients, but keeping a pre-litigation mediation sounding like and feeling like a business negotiation, in part because of the people that are involved, and in part because you're openly exchanging information, I think is quite key to success. And you can use this, the preparation process also to get the mediator involved in helping assess what the witnesses would say. And in this particular instance, I participated in interviews of people who would have been witnesses if there was a litigation or arbitration. It also helped the lawyers get up to speed on the facts, again, using the mediation process as an early case of evaluation tool. And I would say in these sorts of cases, sometimes what ends up happening as a result of the mediation process is that you end up renegotiating the underlying deals. That's not a remedy available to you in arbitration or litigation. And so that has a few implications for the type of neutral that should be involved in a matter like this. You'll want somebody who has life sciences experience, somebody who has some transactional experience, who can help renegotiate the deals and brings a lot of tools to the table, whatever the parties need. So that's a little bit about this scenario and mediation before litigation. Why don't we go to the lessons learned here? Can you go to the next slide for lessons learned?
It's on there now.
Great, perfect. Now I see it. So I would just say, in connection with a very complex collaboration gone south, whether or not you're in a termination mode or a possibly we're going to fix this and renegotiate and move on together mode, it's very important for everybody not to forget the negative effects of filing a lawsuit on the possibility of any new deal or settlement. You can use quite robust preparation techniques and share information to identify claims and defenses and possible business workarounds and the potential settlement value with the help of a knowledgeable mediator. It does help, as I mentioned, if the mediator has experience in business transactions and the general industry. And the parties must invest in the process and not be afraid to share information to preserve a perceived strategic advantage. I remember very clearly asking one litigator to share information that was not the subject of a discovery request in a pre-litigation mediation situation. And he paused and he said, then voluntarily? And I said, yes, relax, no litigation mindset here. The attendees and leaders at the mediation should be business focused to keep the mediation on a business track as long as possible. And ultimately, if you view investment in a robust process as excellent preparation for an arbitration or a litigation and not a check the box exercise, I think that's a good attitude. I've written an article with top 10 tips to an effective and cost-effective arbitration. And tip number 1 is engage in a robust mediation process to prepare. So now I'm going to use that same scenario, ZAPIT and oncology health and the technical collaboration gone south to talk about early evaluation. And I have my little phrase for this. I'm on both sides and this is what I think. That's the difficult part of sometimes of being an early neutral evaluator. But as I said, same facts as the mediation scenario. How could early neutral evaluation help? I think it could be very helpful here. I will tell you that in this scenario, the parties got very stuck on whether or not it was technically possible, given the tools that were available, to make the product work in the particular environment that was on the table. And they really had trouble getting past that. The idea that nobody was at fault was really problematic. And so, as I suggested in the discussion of the menu, in some cases, it's helpful to have somebody tell you what they think. Now, you can do that in the context of a highly evaluative mediation, and I will confess that these processes sometimes blend together depending on how the mediator does the mediation. But if you step into what's officially called an early neutral evaluation, I think that can be effective in breaking these technological impasses. you know, the CEO can say, well, look, an expert told me X. And so at least I got that non-binding answer, and that helps me get past the problem I would have in settling this case if I hadn't had that non-binding answer. I'll just quickly note that the early neutral evaluation process has a classic formation. I direct you to Wayne Brazil's book again. There's a presentation involved. Involving both parties, the presentation that Harry talked about, but with both parties there, no ex-parte communications with the neutral evaluator before the presentation. The neutral evaluator will then write up their opinion. The parties sometimes will say, don't give it to us yet. We want to talk about settlement, or they will get the evaluation and then engage in settlement talks. A good evaluator is very careful to limit and qualify their opinion. They're trying to help the parties tighten and refine their analysis, identify alternative routes of reasoning, additional lines of inquiry, and new sources of evidence. So again, if the neutral evaluation does not end the process and people end up going into arbitration or litigation anyway, it's an excellent preparation tool, a real reality test. And the parties are saying, we are asking this person to give us a firm written evaluation. I also mentioned during the menu using an independent expert as part of the mediation process. In this and some other scenarios, I've asked the parties if they wanted to bring in an expert, someone who was an expert on good manufacturing practices, for example. I did that recently. Somebody who in the oncology health situation was an expert in the physics of the very complicated radiology that was involved there. It really would have required a physics expert. And they didn't do it, but they gave it careful consideration. And again, in order to avoid the next step, why not bring in an expert to help the mediator, almost in a co-mediation setting, to help with, again, a relatively informal but evaluative process that will help parties understand, yes, this is how it might look if we went to the next step. I've got my answer, binding or non-binding as it may be, but it's better than not having had someone take a look at it and really reality test the situation. So I think next we are going on to our next scenario.
What is your tips?
Oh, my tips. Yes, here they are. An early neutral evaluation can be informed and done by a mediator in the course of a mediation with the consent of the parties, either in caucus session or joint session. It helps the parties work hard to identify whether a technical disagreement can be solved through a business compromise, and the parties should consider jointly retaining an expert. That's a little bit repetitive of what I was just saying, but with a few twists. So I hope that was helpful. And now we go on from oncology, health, and zap it to Stephen Gilbert.
Okay. All right. So now Steve's going to talk about what happens if how do you know whether your panel is understanding either the technical or legal issues of your case? Should you employ a tutor? And if so, when? And who should possibly suggest that there be a tutor? Now, Steve has left us with this. An investment in knowledge pays the best interest. Benjamin Franklin. Steve.
Ben Franklin was a smart fellow. So let's go on to the scenario slide, please. Okay, so here we have, this is slightly changed from a real case some of us had not that long ago. So here we have a patent owner selling a fungicidal compound to 3 exclusive licensees for different regions of the world. Each licensee adds adjuvants, dispersants, whatever, and sells its slate of products with this fungicidal compound in different to different folks within its region. At the time of these agreements, the only known use of this patented compound is as a fungicide. And here's the problem area. The agreement allowed each licensee to make and sell whatever product it wanted, provided the principal agricultural activity, note the word principal. Touchy-feely words are wonderful for STEM people, of the patented compound and the product was fungicidal, and that's not defined in the agreement. Okay, so what happened? One of the licensees starts selling a combination product containing both that patented compound and a known public domain unpatented insecticide. The insecticidal activity of the combination is unexpectedly significantly better than that of the insecticide alone. All you patent attorneys should know what that means. The fungicidal activity of the combination was what would be expected from licensor's compound alone. So there's no change, perhaps, and the fungicidal compound itself has no insecticidal activity. So the licensee files some patent applications, and it's likely they're going to be patents granted. An arbitration was commenced because the licensee would not stop selling this combination. Licensor says it's unlicensed because the principal agricultural activity of the compound in the combination product is not fungicidal, but rather is insecticidal. The licensee says, no, it's not. The compound that we buy from you is not acting as an insecticide, but it's acting only as a fungicide. Look, the activity of the combination is fungicidal activity is unchanged, but it's acting as an activity enhancer, making the known insecticide unexpectedly function better. Now, licensor had business reasons for not wanting this combination sold. The parties proposed that a tutorial covering fungicides, insecticides, and related agricultural concepts would be presented before the arbitration evidentiary hearing to the panel by a professor of agriculture who is also an industry consultant and who is not going to testify, and the panel agreed. But what happens during the hearing in connection with the panel's need to determine the meaning of principle in the term principal agricultural activity, each side seeks to introduce statistical evidence from laboratory and agricultural field tests run by both sides concerning, among other things, fungicidal, insecticidal, and catalytic activity. The panel soon realized it needed help with the statistics and the statistical concepts and asked the parties to provide a tutorial. It was amazing, but on short notice, they were able to provide a half-day tutorial to the panel using a local graduate student. He wasn't a chaired professor, but who had the reputation of being an excellent teacher, who had no connection to the parties and who was not going to testify. I have no idea how they found this fellow, but he did a great job. No one had previously appreciated the need for a statistics tutorial. Now, what can we say about the tutorials, such tutorials? Most of the time they should be off the record. I had, once in a while they are on the record, and there's a reason. I had a very interesting tutorial in a software website case in which the claimant said, your website and how it functions is infringing our patent. I didn't know how the website worked, and I would have to know to resolve the dispute, and claimant didn't know. So there was an on-the-record tutorial, and that tutorial served the joint purpose of providing claimant with discovery and also educating me as to how it worked. Another point to keep in mind is sometimes parties disagree about terms or definitions that are important. For example, they have to be understood because they're in the contract, but those disagreements don't come to light until the parties start talking about putting together a tutorial. So, Angie, can we go to the education tip slide, please? So things to keep in mind. Don't assume the decision makers or the facilitators, and by facilitators, we mean the mediator, for example. Don't assume that they know more than they do. If in doubt, ask. Ask about their level of knowledge and understanding. Ask if a tutorial would be helpful, and ask sooner rather than later. There's no harm in asking. This is particularly so
Steve,
if
can I
you
ask you
know.
a quick question? Steve,
Sure.
Steve, I'm sorry, Steve. I have a quick question that just came in. And the question is to you, why tutorials off record rather than on?
Because people are very antsy about having on the record tutorials. They're afraid, and part of this also depends on who's giving the tutorial. If it's somebody who's part of either company and is later going to be a witness, maybe that's not such a good idea. The people giving the tutorial are probably not going to be prepped the way witnesses would be prepped. And people on both sides are concerned about what might be said and whether what might be said could be used to impeach a witness later on. So people are not concerned about teaching the arbitrator, but they're looking down, or the mediator, but what they're looking down the road at is what happens when the teacher, person giving the tutorial, says something that disagrees, may say something that disagrees with what a witness later said. The teacher is not under oath. It's all these interrelated problems. People, you go out and get a professor or somebody who knows something about it, you're not going to spend a lot of time prepping them and teaching them about the case the way you would with one of your own witnesses. So you're concerned about what might be said. It's very common to have written agreements. I believe the Chartered Institute actually has some wording that they use. And I've seen some articles go by, which I could look for and send later, about it being off the record. Okay. It's a good question, but I think we should move on because we don't want to run out of time. Now, back to the second tip. If you know there are going to be specialized areas, science, technology, engineering, or math, for example, statistics is math, in which one or more neutrals needs to have some understanding, consider raising the issue with the other side early and jointly propose, for example. And I think there's more on the next slide, Angie, if you could go to that, please.
Okay, give me a minute.
Okay, so the question is, who's going to be the expert? Outside experts may not be necessary. You may have somebody inside the company, but think about whether you want to use somebody to give the tutorial who's later going to be a witness. You run into some of the problems I mentioned before in response to that question. You don't necessarily need a chaired professor. I heard of one case recently where the local weatherman was the best expert, and the professor from a big famous university, a professor of meteorology, astronomy, so forth and so on, was discounted by the finder of fact, and the local weatherman was given, his or her testimony was given much more credence by the finder of fact, all right? Your own testifying experts may or may not be the best people to conduct the tutorial. Same sort of issues. consider using in-house people who won't be testifying. And as a precursor to having a live in-person tutorial, think about whether there are TED Talks, videos, books, articles that you can agree with the other side might be helpful for smartening up the arbitrator or mediator. All right. Harry, I think you're going to talk about fact-finding now, experts.
Yes, Harry's going to talk about fact finders and neutral fact finders. When should you think about getting one, and should you put it in your agreement? Harry's teaser is just the facts, ma'am.
So this is a situation about a employee that was an executive that was working with a pharmaceutical company, was discharged from the company and started his own company. And the pharmaceutical company sued the former executive for theft of trade secrets. The case was pending in state court before a very experienced judge, but he had no science or technical background. And the case really involved complex chemistry and facts. And so what happened was that was kind of the turning point for counsel to be thinking about, gee, what do we do? And after talking with one another, they then approached the judge and came up with this idea, a proposal of, and with a person in mind, of having a neutral fact finder that would basically help find facts that then in a report would be given to the court, almost like a special master, but in it wasn't a special master, and he would find facts. And then that would be helpful to kind of like a court expert, be helpful to the court. And so what happened was the judge and the parties got together and they said, okay, the neutral fact finder happened to be someone who was a litigator, partner in a large law firm, had done trade secret misappropriation cases himself, happened to have been a retired judge. He was a judge for a couple of years, but most importantly, he had a very good education and experience in the requisite area, technical area. And so what was worked out by the court was the fact finder was permitted to get documents from the parties. There was already, discovery was ongoing, so documents had been exchanged. And in fact, there had already been some depositions taken. But what the court said was, well, suggested that the fact finder sit down with factual witnesses from both sides and interview them. So there was a protective order that kept everything confidential. The people with whom the fact finder spoke were not under oath. It was all, just a conversation. The parties, the counsel for the parties were able to be there. And he interviewed people from both sides on key issues. This was trade secret misappropriation, which is, what were the trade secrets? Were there protectable trade secrets? Were they misappropriated by the executive who left? And were they misappropriated, meaning were they taken and were they used? And the other thing that the fact finder did was made site visits to both companies to see what was being done, how the pharmaceutical company was using their trade secrets, et cetera, and then what was being done by the person who left. And the fact finder put together a report. Before he gave the report to the judge, he gave it to the counsel, and the counsel reviewed it and made a couple of changes, but nothing of real substance to the report. And once the judge got it, he then turned to the parties and said, okay, what now? And what happened was, in the report, it was the fact finder found that there were trade secrets from the pharmaceutical company that had been misappropriated by the executive who left and were being used by him. So the executive defendant in the case said, okay, I won't use them anymore. Offered to pay some back damages, offered to relinquish the stock he had in the pharmaceutical company, which was substantial for under the circumstances. And the plaintiff pharmaceutical company said, okay, this is fine. I will accept that. But we also want the court to keep jurisdiction for about 6 months and the fact finder to be involved to continue to go and do site visits at the pharmaceutical company and have access to the relevant folks to see whether there was continued use of the trade secrets. And that was how that was, that issue about the trade secret misappropriation was dealt with the fact finder. Go to the next slide, please. The takeaways.
Harry, before you go to your lessons learned, I want to read this question. Sure. Are you aware of any arbitral panel ever retaining its own neutral expert witness or consultant in addition to considering the expert witness by each side?
That's a great question. I am not aware. I have not had that. I've been doing this for 20 years. I've never had that experience myself. And I don't know, I certainly would turn it over to see if Steve or Connor's had that experience, but I have not. Steve, you have?
Yeah, why don't we save that for later? Because I'm concerned we're going to run out of time. But
Okay.
I came very close. I did something that was very, very close to that.
Okay.
It's much more common. It's much more common in international arbitration and much more accepted there. I did want to comment on what Harry is saying. It's sounding a little bit like an FTC monitor, sometimes in connection with divestitures and attempts to solve antitrust problems. The FTC will hire a monitor to monitor the activity, post-acquisition activity, to make sure consent decrees are being complied with. So that sounds very much like that creative solution in your scenario.
So the lessons learned are, first, if you don't ask, you don't get. And that really is, it's to encourage counsel, not only for one counsel to talk to another counsel to make a suggestion, no matter what kind of ADR, whether it's for mediation or whether it's here was, kind of the issue kind of screamed out because of the how technical the issue was. And the fact that the judge was did not have a technical background. So approaching your opposing counsel, as well as taking a chance on approaching or suggesting to the court. And then also, combined with that is be creative with ADR for a purpose. And at the end of the day, even though the parties had gotten into some discovery, it really did, when you think about it, it really did shorten what would have been a more complicated trial, and shortened it to, to just the time it took to do this, with the parties feeling that they had their day in court because of this person who had the gravitas and background. And the other purposes in the end, for purposes of the, even though there was already complaint on file and pleadings on file, at the end of the day, it probably helped the executive who left from a PR standpoint. So with that, and because of time, I'm going to turn things back over to Angie.
All right. Our next speaker is going to be Steve. He's going to talk about mock arbitration, and basically he's going to deal with what happens if you want a drive run. What if you want to know whether your case has any possibility of winning or going forward, or what type of issues you might have. Now, Steve has here, who knows what decisions lurk in the hearts of arbitrators? The mock arbitrator knows. Steve?
That's for all of you old-time radio fans. So here in the interest of time, I'll just say two companies had a relationship. They tried working together. Things didn't pan out. Sometime thereafter, the little company that had offered its technology to the big company thought the big company was using that same IP to make a different product. There was there was a lot of money at stake, a lot. And at least one of the parties was concerned enough about the outcome of and arbitration was filed. At least one of the parties was concerned enough to engage a number of arbitrators. It was, I think, about a dozen for mock arbitration proceedings. I was one of those people. I suspect some of the other people on this call, either presenting or in the audience, were some of the other 11 or so. But we didn't know who any of the others were. And the way this company worked the mock arbitration was they were represented by a very fine, large, well-known firm. That same party hired a second large, well-known firm to act as if it were counsel for the opposing party in the real arbitration. Those two sets of counsel provided various written materials, briefs, and other things to each mock arbitrator, and then held oral argument. So there I was on Zoom, talking, listening to counsel from both sides present. And at the end of the period of time, I was asked what I thought. I was debriefed later on to a greater extent. There were a lot of people on the line, including the general counsel, chief patent counsel for the hiring party. I believe they went round robin because after they heard what I had to say, I believe their papers, the briefs were revised, and they went around to the next arbitrator sometime several days thereafter and made the same sort of presentation. So each side was getting feedback from me. So the attacking party, the opposing party, had counsel, this second firm that was hired to represent it, getting smarter and smarter and attacking and defending better and better, and counsel who was really going to represent the party in the real arbitration was also getting sharper and smarter. The process is still ongoing as far as I know. So can we go to the next slide, please? Okay, so consider why you want to hold a mock arbitration. If you do you want to get insight as to how an arbitral panel will rule on some or all of the issues before the demand is filed? Do you want to get some insight into how the specific panel you have will decide? This is like a shadow jury where jury consultants come in and try to replicate the 6, 10, 12 people, whatever it is, on the real world court jury by presenting and seeing how the shadow jury rules, trying out arguments, just hearing what the other side has to say. That will help you figure out that, and how much is at stake will help you figure out what you want to do. Do you want to settle? Do you want to suggest mediation? Do you want to file a demand? If it's already been, do you want to go to litigation? Just see what's going on. Can we have the next slide, please? Okay, and then in actually running the mock arbitral panel, do you want to present to all the people on the panel at once? Do you want to do them in smaller groups? Do you want to do them such as one at a time, which is what I think was done in my case? And what was done in my case was they would debrief each arbitrator after they had presented. So again, this is something where the cost was minuscule compared to what was the cost of the mock arbitration, even with about a dozen arbitrators and 2 high-powered law firms presenting. The cost was minimal compared to what was at stake. Okay, Angie, I think I have the next one, and I think you wanted to do some introduction.
Yeah, I do. I'm going to just out of abundance of time here, we would be remiss here as to not bring up any examples that involve patent law. And what happens with patent cases, as you can see on the slide, there's a statute that provides that if you have an arbitration award that involved the patent, that it must be filed with the patent office. And so the question here becomes, how do parties deal with this notice requirement and desire to create confidentiality? You don't want necessarily your competitors to know that this arbitration even occurred. Steve?
Yeah, again, in the interest of time, all right, 35 U.S.C. 294A allows arbitration of validity and infringement. It's always been interesting to me, the word enforceability is not in there. And 135F deals with derivation proceedings. In 2011, we did away with first to invent and went to first to file. So interferences, patent interferences were done away with, and there's derivation proceedings instead. And both sections say you can arbitrate and that the result's not binding. And they both say to be enforceable, the award has to be filed with the director of the patent office. Okay, now what happens in the real world? Again, in the interest of time, you have a US patent. It's often the case there are foreign patents, but not necessarily. So if you, in analyzing, and if you have a multinational patent dispute, there's a few ways you could think about resolving it. You could have the dispute for each country's patent be dealt with according to the law, that country's laws, or you could agree that the dispute from a particular country will be used as the representative or test case, or you could try to establish your own law concerning patents, or lex mercatoria for law merchant. The third choice is probably not so great. On top of that, you have what we've been talking about confidentiality and the award being unenforceable unless you file with the patent office. And on top of that, you have the fact that some countries don't allow patent disputes like things like validity to be arbitrated. The example that's typically given of a country like that is China. So what do? If you have only a US patent that you have to arbitrate, you can have a simple award without reasoning. So even if it gets filed, you don't know. You can't tell very much from a simple award most of the time. You could have a simple award that gets filed, but you could have reasoning set forth in a separate document that doesn't get filed. Or you could have a reasoned award which is filed, or you could have a reasoned award which is not filed. My impression, and I have no way of having any statistics on this, is that most patent arbitration awards don't get filed. If you have US and foreign patents, one of the things you could do is pick out one of the patents, a non-US patent, for example, is the test case. And say, if you decide the validity of the patent from country X, pick a country, England, Germany, Japan. If you have a patent that's held, that the arbitrator finds is valid there and infringed, then you're going to, the parties agree that whichever way the arbitrator goes on that is going to be binding on the dispute regarding all patents. What do you do if you have if the patent of a country that doesn't allow patent disputes to be arbitrated is part of the mix? Instead of having the arbitrator declare that the patent's valid or invalid, you have the arbitrator declare how the arbitrator believes the administrative or juridical body that does have proper jurisdiction over that dispute in that country would resolve that dispute with respect to that patent if that dispute were presented to that appropriate body in that country. It almost sounds like an advisory opinion, but again, and in some sense, that's what it is. So you're not asking the arbitrator to violate the rules of that country, the laws of that country. What you're asking is, Mr. or Miss Arbitrator, what do you think the appropriate administrative or juridical body of that country would do, country X, let's call it, if a patent issued by that country, which has the same sort of coverage as a US patent or the British patent, whatever, if that dispute were presented, that's the way you could deal with countries that don't allow patent disputes to be arbitrated. I also indicated I would try to answer that question about appointing an expert. Yes, I had a case in which, I'll come back to the tips in a second. I had a case in which at the end of the hearing, I was chair, the panel did not think it had enough information to make a decision concerning some very nitty-gritty financial information involving hundreds of thousands of computer records. We got the two sides to agree that a forensic accountant would go in and examine the books. That forensic accountant then wrote a report. Each side was allowed to comment on the report. We held a telephonic hearing during which we aired all the concerns each side had raised about the report. The forensic accountant issued a supplemental report. And that's how we got the answers to the questions that we needed. And that's the closest I ever came to saying, we, the panel, are appointing an expert. We did in a sense, but we sort of, we got buy-in from both sides. They agreed upon the forensic expert. Back to the forensic accountant. So patent arbitration tips. Listen, you can get patent attorneys, you can preserve confidences, you can do all sorts of wonderful things with arbitration, but you still have confidentiality issues because of 294 and 135F requirements. But there's, and if it's multinational, you have these other issues we've mentioned. There are ways around it. And I think these are some of the ways. By the way, the ICC recommended what I suggested with respect to a country like China back in 1998, that the parties agreed to pose the dispute as being, what would happen if this dispute were presented to the appropriate body within that country to make a decision?
Okay. There's a question here, Connor. I think it's probably directed to you, although we all are mediators, but you did talk about mediation. It says, for the mediators, are you seeing a trend towards multi-day mediation in these disputes? And I'm assuming they're talking about life sciences disputes.
Right. Thank you, Mr. Davidson. Hi there. For asking that question. It gives me a chance to emphasize a point I failed to, which is in these disputes, I have found people are willing to view mediation as a process that happens to include in-person sessions, but also consists of a tremendous amount of preparation before you get together to talk about how you're going to resolve the dispute. So in that connection with the scenario that I discussed, it was a 4-month process that involved me going on site, interviewing people that would have been witnesses. It was all part of the mediation process, and it involved in-person meetings and sessions. But we didn't really get into what would be called a classic mediation until much preparation, documents, and discussion had transpired. And the process went on for a couple of days and had follow-up. So it makes everybody relax. These disputes are very complicated. Preparation makes success much easier to achieve, success meaning an agreement, than avoiding arbitration or litigation. So the answer is yes, with some prodding. These are multi-day processes. And the classic mediation sessions tend to be more than 1 day.
Okay, I think I don't see any more questions. So I'm going to give each of the panelists a 15-second conclusion. Harry.
Yeah, I'm actually just going to add to what Kana said, because I think it was a very good question, which is I would say that the in many of these cases for mediation, not only are they multiple in-person sessions, but depending upon how much the technology is involved or talking about the field or it depends how complex it is, but a lot of heavy lifting occurs before. So after getting the briefs, particularly ex parte briefs, I will call and spend quite a bit of time with the parties to make them feel comfortable that I understand the issues, the technology, all of that stuff. Try to start digging in so that when you get to the in-person session, you can actually start to feel like they've had you understand what their issues are, their interests are, and then start to work on the framework for a deal. It doesn't mean that some of those other issues, don't come up again, but the heavy lifting really helps in advance.
Steve?
Nothing to add other than it's been a pleasure working with all of you, and I hope everybody on the line is well and stays well. And I would add that I think it might be the very first step from the very first scenario. If people really want to solve a problem, they can usually find a way to do it without spending a ton of money and diverting resources and beating each other up on the head for years, perhaps.
Connor?
I would just add, don't forget to think outside of the box. Start with self-help. You can, even as a mediator, suggest that the parties get together without you and engage in some of those self-help techniques that Steve identified. And don't forget to be flexible and combine processes. Try to figure out what is at the root of the dispute and focus on using the tools we've discussed today to resolve that and keep parties, get parties back to business, especially in our COVID-19 world.
All righty. With that, we say thank you all for joining. I think I saw something like 33 attendees, so thank you very much.
Thank you very much.
All right.